Hello, welcome to our podcast. It's brought to you by the Touro Law Review and the Touro University Law Center. Our guest today is Professor Ray Brescia, and we're going to talk about his book, Lawyer Nation, the Past, Present, and Future of the American Legal Profession, a truly significant book that we're fortunate enough to be able to talk about today. So, Professor Brescia, welcome.
Thank you. Thank you for
And
having me. I appreciate it.
so
Thank you
it's
for
our
that very
pleasure.
kind introduction.
And well, I'm going to give you a chance to elaborate a little bit because we do have a lot of student listeners, and it's always of interest to them to learn a little bit about our speaker, uh, how you ultimately came to be a professor and came to be with us today in terms of your career path. So please tell us about that.
I would love to. Thank you. It starts in Huntington Village, where as I was growing up in the late 70s and early 80s, Touro Law School's first building was. So I used to pass it quite frequently. So I grew up on Long Island, went to Fordham University in the Bronx, and I think there really developed a concern for social justice issues. It was the mid 80s. There was a homelessness crisis that was burgeoning at the time, and vacant buildings in the Bronx, and a lot of crime, and got started on working on social justice issues through the Fordham University Community Service Department, and had thought for sort of the later years of high school that I wanted to work in law. It was very interesting to me, the combination of law and politics. And then when I saw the social justice issues as so dire and so needing of being addressed, I wanted to do my part, and went to law school, and continued to work on homelessness issues in law school. My law school had a clinic that was focused on homelessness, combating homelessness. We set up literally set up card tables in homeless shelters and soup kitchens to provide legal services to people who were using those services. And I was then fortunate after law school to get a position with the Legal Aid Society of New York as a Skadden Fellow, working in East Harlem, working mostly in northern Manhattan, Washington Heights and Harlem and East Harlem, in representing tenant associations, doing housing advocacy, and really found that work to be incredibly rewarding, challenging but rewarding. And then clerked. I had the great honor of clerking in the Southern District of New York for Constance Baker Motley, a civil rights queen, as she has been described in a recent biography, which was an incredible experience. I would recommend clerking to anyone who has that opportunity to do it. I joined New Haven Legal Assistance for a year, came back to New York City at the Urban Justice Center. Through much of those years at the Urban Justice Center, I was a adjunct professor at New York Law School, which really gave me the bug to teach. And then when my spouse got a position in Albany, I was very fortunate to land a position teaching at Albany Law School, and I kind of haven't looked back.
All right. Well, that's certainly some impressive milestones along the way. I find it interesting. You don't just talk the talk; you walk the walk, and that's certainly admirable. And your early interest in the intersection with law and politics, I mean, certainly social justice is one area that really demands, I think, that the lawyer have a political perspective as well. I mean, so many policy decisions affect what the lawyer can do. So now, if we turn to your book, Lawyer Nation, Past, Present, and Future of the American Legal Profession, It's significant analysis and critique, but also offers suggestions with respect to the profession. So let me ask you to, uh, I mean, I can't say summarize the book, but just present maybe an overview, and then we can discuss some specifics.
Sure. I'll really, start with the methodology, if that's okay, which was, or the challenges I was trying to address. So, when I started working on this book a couple of years ago, it was in the throes of the COVID crisis, the George Floyd crisis of police response, and that was affecting the practice of law. Those two crises, but also other crises as well, like the access to justice crisis, the fact that 80% of low-income people and 50% of middle-income people in the United States can't afford an attorney. The rising role of technology in the practice of law, and whether that was going to impact the displaced lawyers, the sense of disaffection that many lawyers face. And we have high rates of substance abuse in the profession. We have high rates of suicide in the profession. And something was terribly amiss, I thought, and still think, in the profession, and the profession is facing a series of challenges. And so that was, those, trying to address those challenges was really the goal of the book. And then another one came along as I was writing, which was the crisis of democracy, and the events leading up to and of January 6th, which lawyers had a significant role in, and we can talk in greater depth there. So, looking at these six crises, and having looked at the legal profession's crisis response over the years, it struck me that the profession's crisis response has been quite weak when we face things like Watergate, and lawyers had a hand in that, savings and loan crisis, the foreclosure crisis, and the financial crisis, 2008, 2009, all of these with lawyers playing significant roles in them, and the profession sort of getting into this lather, rinse, repeat cycle, which is we have a crisis, we kind of do some stuff on the margins, and we don't really make significant change, and lo and behold, another crisis hits in a few years. So I tried to really think about, okay, what was a time when the profession made significant changes to address a range of crises. And I looked at the time. I really focus on the book significantly on the time, sort of the late 1890s, early 1900s, that the turn of the century, when the modern legal profession was really created, in response to a series of crises, not unlike the ones we face today. I can get into them if you would like, but if one thinks about, what are the sort of contours, what are the key components of the American legal profession when we think about them? When we think about the legal profession, what do we think about? We think about law firms and bar associations and bar exams and law schools, codes of ethics, and even the sector I worked in, legal aid office, public interest offices. Those are, when people think about the legal profession, that's what they think about, right? Those are the contours, those are the components of the contemporary legal profession. Well, those were created 150 years ago, right? Before the 1880s, virtually none of those components of the legal profession even existed. And so, we created those institutions of the profession at the turn of the 19th to the 20th century in response to significant crises that echo or rhyme with the crises of today. And maybe we need to go back and look at those institutions and assess, do they need to be reformed? Do they need to be abolished? Do they need to be, changed dramatically? I hope we won't tweak them around the margins. So that's the kind of conceit, if you would, of the book. We're facing a series of crises. The legal profession tends to not really address the crises it faces. The last time we did, we created a new legal profession for all intents and purposes. It's one that we have today, right? A lawyer in 1930, looking backwards, would recognize the profession of today more they would the profession of even 30 years before that.
So,
So that's the framework, and I'm happy to talk more about it.
well, that's fine. And I want to pick up on a couple of things. Uh, when you read the book, you'll see, reader, that the later chapters do talk about these crises, the and dynamics. The earlier chapters do talk about some of this history, but 2 points I'd like to make. One is about our deity, which we could maybe address second. But the first point, based on what you said, you're talking about methodology, and you list the institutions that were created, century ago, plus. But you do, with respect to methodology, you take a sort of an economics, certainly economist definition of institution that helps frame your discussion. So I know maybe it's a little technical about methodology, but why don't you explain uh, how your view of institution and how you picked the definitions that you did?
Sure. So, economists tend to talk about institutions as, rules and norms. And I think the layperson thinks of an institution generally as an organization, a law school. But there also are institutions, practices, and habits that are embedded in organizations. And you might think of something like the filibuster in the Senate, right? Yes, it is a technical rule that governs when legislation can, come for a vote. But it's clothed in this concept of collegiality, of the Senate is supposed to be an entity that considers legislation in a deliberate manner. Now, it has its history too, and there's history of the filibuster being a product of Jim Crow motivations, right? To make sure that the minority continues to dominate. But the institution of the filibuster is a norm embedded in the institution of the Senate, which is a body, a governmental entity, and it has these sort of uh, 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 you know non-corporeal elements to it too, right? To the
Mhm.
spirit of collegiality and deliberation. So institutions are used in a lot of different ways in a lot of different disciplines. I use institutions both as norms, and habits and practices, but also as entities where those norms and habits and practices are institutionalized.
Mhm.
And the norms of the legal profession. The legal profession is itself an institution, but its norms are embedded in its codes of ethics, in its bar associations, in its law schools, in its courts, and the manner in which lawyers deal with each other. So that's a bit esoteric, I agree, but I think it's important to think about the ways that norms, habits, practices, laws, regulations, codes have a way of channeling behavior and the practice of a group, a body, there's a sort of path dependency that sets in once you set the rules of the road, right? And I think that we had a profession that set the rules of the road 150 years ago or 130 years ago or so, and we've gone on a path since that has put us in the place we are now.
Yeah, right. So, I mean, that is a sophisticated definition. It draws from a couple disciplines. And so I do think it was important because it certainly frames, it's the sort of overarching analytical concept to keep in mind. It's sophisticated, but there's a great metaphor, I think. And you draw from a Greek deity, and I do think it helps also to clarify what you mean by institutions and what needs to happen in a general sense. So why don't you tell us a little bit about your metaphor of
Sure. And you said the deity before, and I wanted to clarify a deity, right? So
yeah,
the deity that I use as a metaphor is Janus, which is a god who had two faces, and was both the god that looked backwards and forwards. That was the idea of the deity, but also the god of transitions. And so, the book tries to look backwards and forwards, and to consider the transition phase I think the profession is in now, and to try to chart a course forward for the profession so that it continues to uphold its most important values.
all right. And let's turn to that. And I normally don't like to read, but I'm going to read one particular sentence that comes from the introduction that really, to me, is one of the sentences that encapsulates uh, what it encapsulates the critique, encapsulate what needs to happen, but also the challenge of that. And so, if our listeners will bear with me, you state that you argue that the institutional role of the American legal profession within the United States is primarily to defend democracy, promote the rule of law, advance civil rights within a multiracial community, further economic development within a market economy, and preserve individual liberties, all within an adversarial system of justice. And so I found that very interesting. And I mean, again, you could say, well, that's the book, but if you could sort of explain the challenge of achieving these changes and getting back to the essence of the what the profession needs to do, while at the same time working within an adversarial system, which of course then creates a challenge to accomplishing the things you need to accomplish.
Yeah, so thanks for that. And you really, put your finger on, I think what I think is a core argument in the book. And I use this to borrow from the sort of institutional framework again. I use this concept called institutional fit, that is often used in the environmental context to say, what are the norms, practices, laws, and rules that you want to deliver on or that are appropriate to a particular setting, right? What are the norms and practices appropriate to a setting, given your goals, given the needs of that setting? And so for the American legal profession, and that's what the book is about, the setting is one of a democratic republic, that is designed to be, and forgive the gendered language, but a nation of law and not men, as John Adams said, that is made up of a multiracial populace where people are supposed to be equal before the law, and to have their civil rights honored. We're a participatory democracy where people are supposed to engage in the practice of democracy, elect their elected officials to bring and realize the voters' will, and we have a market economy, and we believe that the our system of justice, the American system of justice, is one of procedural justice, and adversarial justice, and that rather than a government, or a religious figure inspired by a deity is supposed to make decisions for people, we believe in procedural justice, that where able adversaries come together, advocate for their client's interest with zeal, and through that system of procedural justice with actors in it, operating with zeal on behalf of their clients, a fair outcome will result where the participants in that process will accept the outcome when they recognize that there was procedural justice and their advocate worked for them with zeal. So that's those are the principles
Mhm.
of our environment, if you would, our legal environment, and a legal profession should calibrate its practices, norms, and habits and values to satisfy those elements of our legal environment. That's the core argument in the book.
All right. So let's maybe talk about some of the specific contexts where that argument, where that dynamic comes into play. Maybe I'll start with one, and then you could you can pick one after that. But I found January 6th interesting in terms of the analytical framework of your book, and perhaps you could apply to that context. One thing I found interesting about that, and I'm using the word interesting, just trying to stay as neutral as humanly possible, which is, not so easy. But there, lawyers who made anti-democratic arguments were ultimately sanctioned. I mean, some of the lawyers, the cases were brought. Uh, the former president lost all those cases, basically. Dozens and dozens of them. And then some of the lawyers who brought those cases were sanctioned. So, what about January 6th worked? What didn't work? In terms of how you're trying to get the profession and the institutions of the profession to move in a more appropriate and value laden way.
Well, let's break down the effort to overturn the election. I think let's talk about it as having three different prongs, if you would. The first is seeking to throw out votes in individual cases, not individual votes, but in cases brought in, heavily Democratic districts, within states, to challenge the results of the election in a particular state or a particular city. And there were, as you said, there were dozens of those cases. I think the count is about 65. Um, Almost none of them got past what we refer to as the motion to dismiss phase, right? So that, like, on their face, there was no basis for those claims, or rather, they had no merit. So that would be, the first line, the first prong. Most of those cases were dismissed as without merit. In a number of them, it's not just that they had no merit, but they were patently frivolous, right? So lawyers were sanctioned in many of those cases for bringing those frivolous lawsuits. So that's prong number one. Prong number two is the effort to create false sets of electors, which is very much connected to prong number three, right? But let's talk about the effort to create false slates of electors in 6 states, right? The swing states that the Biden-Harris ticket won. That was orchestrated by lawyers. Several of those lawyers have pled guilty in Georgia to crimes related to that, to falsifying records and things like that. So and some of those lawyers are also facing disciplinary punishment, discipline. The final piece is the sort of argument, the third prong, which was sort of the impetus, if you would, for the events of January 6th itself, that the somehow a legal argument was crafted, and I use that term very generously, was crafted that the vice president could disregard the votes of some of those same six states, those 6 swing states. The main architect of that was John Eastman. He is currently facing disbarment proceedings. Another character who is involved in related matters was Jeffrey Clark, a DOJ attorney, is facing disbarment in the District of Columbia. Rudy Giuliani was involved in that effort as well. He has been suspended from the practice of law in New York State. He is facing disbarment in New York State and in DC, as I understand it. So we're still, no one has faced consequences for the events of January 6th yet, except for Rudy Giuliani, former Mayor Giuliani, who has been suspended temporarily from the practice of law in New York. So, we still, while his disbarment proceeding is pending. Relatedly, I should say, he also has been found liable to the 2 election workers in Georgia to the tune of nearly $150 million. So after the fact, right, like after the horse has left the barn, the profession and courts have tried to, close the barn door, as they say. Is that structure sufficient, right? That we, after something like this happens, we close ranks and we say, okay, those who took those actions should be held to account. I hope that before January 6th, 2024, that some of the individuals involved in in inspiring the events of January 6th, because I don't think that many of the people who stormed the Capitol had really read the Electoral Count Act and on their own had decided that the vice president had the authority to overturn the election. I would be surprised. So that, the impetus for that event was inspired by lawyers. And the arguments are utterly baseless. They're simply baseless. I've represented clients in cases that some might consider political. I have raised novel claims, our rules of ethics and our rules of procedure say that you have to file claims only if you have a good faith basis for making them, that you have a good faith basis for the reversal, modification of existing law, excuse me, the reversal, modification, or extension of existing law, but you have to have a good faith argument for making it. The argument, and you can even read some of the internal memos and emails from some of the lawyers that were making these arguments. They knew that there was no basis. Their argument was, all we need to do is throw up enough smoke, throw some sand in the gears, and maybe slow things down so that we might be able to get the results of the election tossed out, so that there's enough there are enough questions that the election would be thrown into the House, where the House of Representatives, where based on the quirks of the law, each delegation from a state has one vote. So if you did the math, at the time, the Democrats, although a new Congress had been sworn in, they knew that a state by state count would have meant that the former president would have been reelected. So that was the strategy, right? Throw sand in the gears, raise enough questions, even if those questions were utterly baseless, so that they could overturn the results of the election. So, like I said, I've worked on cases. I've worked on some cases that were political. I've worked on some cases that some might argue were creative. But anytime I did, I always had a good faith basis for the reversal, extension, or modification of existing law.
Yep.
The people who concocted, and that's a better word perhaps, the legal strategy, what a lawyer in the White House said was, you're a serpent in the ear of the president, right? Whispering in the ear of the president, oh, you can do this, you can do this. It's illegal, but you can do it. And that's not the proper role for a lawyer. Sorry for that long-winded answer,
No,
but I
no,
wanted
that's
to get into
interesting.
it.
And I mean, if I could generalize just a bit, one of the points that you've made is that the institution, it can do some things after the fact, but it's deficient in trying to prevent the harm before the fact. And I think that's, sort of a crude generality of one of your primary criticisms. All these noble goals which we should be following, the institutions don't help. Maybe they punish after the fact, but they're not remotely proactive. I mean, is that a fair summary?
I think that's right. So the way we think about the punishment for this sort of conduct is that the punishment should be significant to deter future action, right? Whether it's the person who's being punished or others. So there's a bit of a rift in the time-space continuum, right? We have to have a punishment that would deter this from happening in the future, but we're acknowledging that the conduct has already happened. And moreover, although we talk about in what's known as the preamble to the model rules that govern lawyer behavior, talks about the importance of the rule of law. We don't make a distinction in the rules themselves about frivolous conduct that might be in a case with very low stakes, a case that might be over a personal injury matter where the plaintiff is seeking $10,000 for some lost wages, and a case that tries to bring down the republic and intervene in and prevent another institution, the peaceful transfer of power that has, marked our democracy for nearly 250 years. So, I think moving forward, we shouldn't just have platitudes in the preamble to the rules, but rather the rules should make it quite explicit that a body that is a body considering rule of law undermining actions is well within its rights to punish the lawyer who engages in such actions significantly, and that the rules should make clear that that punishment is forthcoming. Again, it's hard to prevent conduct generally, but making it explicit that the punishment will be severe should a lawyer engage in rule of law undermining activities. Hopefully that will have a deterrent effect. Clearly, what we have on the books didn't have a significant enough deterrent effect because people went out and did it.
All right. So, thank you for letting me focus on January 6th for some of this.
I devote an entire chapter to
Yeah,
it, so
I know, but
I
you
welcome
allowed me
that
to pick,
focus.
you allowed me to pick one,
Yeah.
which I appreciate. We have some time left. It's growing short, but we still have really enough time for, now I'll ask you, if there's any focus that you would like to expand upon, or really any point that you haven't made that you'd like to make, or a point that you have made, but perhaps develop it in a way that my questions didn't allow you to do.
I think that if we're coming to the close, I wouldn't want to not mention recent developments in terms of diversity, equity, inclusion, and belonging in the legal profession, which is I talk about these concepts and the importance of them in a chapter where I also talk about the law, the legal profession's response to the COVID crisis. Because I think in some ways they are connected, and here's one way in which they are, which is, we had on February 1st, 2020, if you had surveyed, partners in law firms, judges, law professors, deans of law schools, and said, hey, how much of what you do could be done virtually and effectively, in a way that was inclusive, that helped people who might have trouble accessing the law, the courts, and lengthy commutes are difficult for them for various reasons. They have family obligations. What percentage of what you do could be done virtually and done well, and still meet the goals of what you're trying to accomplish and what the legal profession needs to accomplish? My guess is at that time, most of those people polled would say, oh, very little of what we do. There's so much that we have to do in person. There are so much that we have to rely on in terms of the gatekeeping that we do to make sure that we have competent lawyers who graduate law school and go out into the community. All that changed virtually overnight in just a month and a half later, right? Mid March 2020. And I want to think about that, or use that as an example of another metaphor, if you would, which is, the legal profession, and I think that the book shows anything, it shows that we've changed very little over the last 130 years or so. Although the demographics of the profession have certainly changed a little bit. So in 1875, it was almost exclusively white men of Northern European stock who were Christians who were lawyers. That's just who the legal profession was, 150 years ago. We've changed the demographics of the profession, some, at least in the lower ranks, if you would. We still have a far way to go in its leadership ranks. But so I use that metaphor, or I think about the transition to virtual practice, as a metaphor for the idea that the profession actually can change if it wants to, and if it sees the need to, which is what it did. And in that world, right, that transition, there were kinks to work out for sure. There are things that we still need to work out in terms of in person, younger lawyers getting good mentoring, making sure people don't fall through the cracks because of the digital divide. But our the being set in our ways about what we think, who deserves to be a lawyer, who can be a good lawyer, how they practice, where they practice. Like, I think that we can actually change. We can actually change, and we've proven that we did it. And for in many instances, people said, "Hey, we can do that this way," and it's a little more humane, and it's a little better, and it's more inclusive, right? So if we can do that, maybe we can transform the profession as a whole as well. We don't have a lot of experience with that, but we have shown that we could when we needed to, and I hope people feel that same sense of urgency that we do need to change the profession in ways that make it more inclusive, more professional, more diverse. And my book tries to chart a way forward. Although I welcome a lot, there are many people who are doing really great work in these areas, and it's just an honor to be in conversation with some of them.
Well, that's it's been an honor for us to have you. We have to bring the podcast to a close, but the book can be opened. There is a fascinating and in-depth discussion of institutions, methodology, history, and then an analysis of six crises and dynamics, and Professor Brescia's suggestions as to how to accomplish some very necessary changes. So our guest has been Professor Ray Brescia, and we've been discussing his book, Lawyer Nation, The Past, Present, and Future of the American Legal Profession. Professor Brescia, we thank you for being with us. This has been the broadcast of the Turo Law Review. I've been your moderator, Turo Professor Peter Zablotsky. Professor Brescia, thanks again.
Thank you very much, Professor Zablotsky. It's been an honor.